Tisha, you may start with the session.
Okay, sir. Good evening, everyone. In week first, you learned how to attack, how to file a complaint. In week two, you learned how to negotiate, how to quash a case. But today, we enter the most critical phase of a criminal lawyer's life, the shield. Imagine this: you are innocent, you are at a dentist clinic getting a root canal, but suddenly your phone rings. It's a police officer. He says, "You are accused of theft. We are coming to arrest you. Your reputation, your freedom, your future hang by thread." This is the nightmare scenario we face in week third. To save your client from this arrest, you need more than just innocence. You need strategy, you need anticipatory bail. To teach us the art of bail, we didn't just want a theorist, we wanted someone who fights these battles in the trenches of session court. Backed by the highest academic caliber, it is my absolute honor to introduce our expert mentor for today, Advocate Priyanshi Garg. Ma'am is practicing advocate at the District and Sessions Court, Agra, where the real criminal trials happen. But her legal foundation is elite. She's completed her BBA LLB from Gujarat National Law University, GNLU, Gandhinagar, one of the premier national law university in our country. Her academic journey is nothing short of inspirational. Not only was she awarded a scholarship for 2 consecutive years for her outstanding performance, but also she graduated as a gold medalist. This combination, a GNLU gold medalist who chooses to practice in a hard-hitting environment of the district courts, make her a formidable legal mind. She knows exactly what convinces a session judge to grant bail when a police are demanding custody. Interns, you are about to learn the shield strategy from one of the biggest mind in the field. Ma'am, the virtual podium is yours.
Thank you for the introduction, Tisha. First of all, my greetings, everyone. Greetings to one and all who is present here in this session with us today. So, today we are going to examine one of the most intellectually fascinating area in the criminal law, in the criminal jurisprudence, and that is the concept of anticipatory bail. The anticipatory bail, and in order to make it a bit more interesting, bit more intriguing, we will be trying to learn how to draft an anticipatory bail backed by the plea of alibi, which is, and therefore, I have divided this session into four major components. Firstly, we'll be dealing with what anticipatory bail actually is. We'll be dealing with the statutory provisions of anticipatory bail, understanding it word by word. Then later on, we'll move to understand the basic conceptual understanding of the plea of alibi, especially in light of Section 9 of BSA or Section 11 of Indian Evidence Act. And thirdly, we'll ultimately come to the drafting part of anticipatory bail, which is the core of today's session. So let's begin with the foundation. Number one, anticipatory bail is not a mere procedural remedy. We have to understand this. Rather, it is a constitutionally backed device, which is also provided for under Article 21 of the Constitution of India, if not directly, but by implication, because this article protects, it guarantees our right to life as well as personal liberty. And arrest, it is a major invasion of our personal liberty. Therefore, anticipatory bail exists to ensure that the power of arrest is not abused by police authorities so that our constitutional right, our fundamental right to life and liberty, is not curtailed for the mere sake of investigation. So, coming to, could we please switch to the next slide? Yes. So anticipatory bail, as I was saying, it it is a serious invasion of our liberty, and therefore arrest is a serious invasion of our liberty, and therefore this device of anticipatory bail prevents us from harassment, coercion, and also from the punishment before trial. If you may please switch to next slide. Thank you. So herein we'll be dividing section 482 of Bharatiya Nagrik Suraksha Samhita ingredient by ingredient. In fact, word by word. If we look at the main provision of this section, it says when any person has reason to believe that he may be arrested on an accusation of having committed a non bailable offense, he may apply to the High Court or the Court of Session for a direction under this section. And that court may, if it thinks fit, direct that in the event of such arrest, he shall be released on bail. Now let us just divide it word by word, phrase by phrase. So the number one phrase is where any person has reason to believe. So the ground is, the standard is that there is a reason to believe. Mere fear is not enough. There has to be an objective basis. There has to be something that gives rise to reason to believe that you might be arrested. So, for example, there is an FIR against you, or there is an inquiry or investigation pending against you, and you are apprehending arrest. Coming to second ingredient, coming to second phrase, that is that he may be arrested. So, we have to see, even from the marginal heading, we have to look at that he may be arrested. It is not sure that he will be arrested. The accused is apprehending arrest. So, in anticipatory bail, we demand for a preventive remedy. It is not a cure. It is, we are saying that this FIR or this such and such, it is false or so and so, and therefore we are coming before the honorable court to to get a relief of anticipatory bail so that we can be prevented from the humiliation of being arrested. Secondly, if we look at the marginal heading of section 402 bns 482 bnss, it says direction for grant of bail to person apprehending arrest. This means the arrest has not yet taken place. The accused person is apprehending arrest only as of now. There's no certainty. Therefore, we say that anticipatory bail is a shield. It protects you from arrest and not a cure. That is, if we come to next phrase, it is on acquisition of non-bailable offense, on accusation of having committed a non-bailable offense. So here are two elements that we can see. Number one, there is an acquisition. That is, there is an FIR or there is an accusation that you have committed such and such offense. And number two, the offense that you have been alleged to have committed, it is a non-bailable offense. If it is a bailable offense, then you don't need to come before the honorable court to ask for bail, because in bailable offenses the police officer itself is empowered to grant you bail, and in bailable offenses it is your right to get bail from the police officer itself, and you don't need to knock the doors of the court. If we come to next phrase, it says he may apply to High Court or Court of Session. This means that both High Court and the Court of Session have been given a concurrent jurisdiction under section 482 of BNSS. It means you have the option to either approach High Court first or the Court of Session first. However, in practicality, what is done is we pay respect to the hierarchy of courts according to them, and therefore in practice, we prefer to approach Honorable Court of Sessions first, and if required, later on we can go to Honorable High Court. The next phrase is for a direction. So, what are we asking for here is for a direction by the Honorable Court that anticipatory bail be granted, be please granted, and therefore it is not a ordinary bail. It is not an ordinary bail wherein first you are arrested and then you file the application for bail. In ordinary bail, first you are arrested and then you go for application for bail and for relief of bail. However, in case of anticipatory bail, what we do is as soon as we apprehend that we might be arrested in future because of so and so offense, we approach honorable court and say and ask for a relief with the direction of the court that in the event of arrest, by police, I may please be granted bail. So, what essentially this section is doing is converting a non bailable offense into a bailable one, wherein the non bailable offense are not such that can be granted bail by police officers. You have to approach the court to get bail non bailable offenses in case of ordinary bail. However, in order to get in order to make it more simple, in order to ensure that your liberty is not curtailed at the first instance, what we do that even before the arrest is made, only if we are apprehending that there may be an arrest that could be made, then we approach honorable court asking for a relief that in the event of arrest, please direct that the police officer release me on bail, and that bail is conditional that you will be released on bail only when you furnish bail, obviously. Therefore, we must pay attention to this crucial aspect that anticipatory bail does not mean that you won't be arrested. We cannot uh, equate anticipatory bail with no arrest. What it means that in case of arrest, you will be released on bail by the police officer itself. You don't need to approach the court then, provided you are obviously ready to furnish the bail. Therefore, arrest may occur, but the release is guaranteed by anticipatory bail. Then the next phrase is in the event of such arrest, he shall be released on bail, which shows that anticipatory bail is conditional. It is conditional on the fact that you are arrested, and then when you are arrested, you get the right, if you have the anticipatory bail, to be released on bail. Therefore, anticipatory bail becomes operational only when the arrest happens. Now, if we look at, uh, we all know that bail is granted by courts on certain conditions. So, the conditions that can be imposed by High Court or the Court of Session can be related to that. Please, you are required to cooperate in investigation, that you won't leave India, you won't influence any witness, or you don't will not tamper with the evidences. Essentially, many more by the honorable court given the facts and circumstances of each case. So essentially what these conditions do is to ensure that the triple test is satisfied. What is triple test? Triple test is that there is no flight risk, there is no tampering. Flight risk as in you will abscond, you won't appear before the court when trial will be happening. Then there is no tampering. Tampering means tampering of evidences. You won't influence the witnesses. Then, at last, that there is cooperation with investigation. That you will cooperate with police officers, with the investigating officer, so that they can perform their duty and investigate the case properly. If we may please switch to next slide. There are various important and landmark judgments on this concept of anticipatory bail, but I am here with two most important judgments. And number one is Gurbaksh Singh Sibba versus State of Punjab. It is a 1980 Supreme Court judgment. Herein, the constitutional bench laid down certain principles regarding anticipatory bail. Earlier, what was done that anticipatory bail was taken as an extraordinary procedure which was not available in normal circumstances. The courts used to think that it is available only in certain exceptional circumstances. However, in this case, Honorable Supreme Court made it categorically clear that anticipatory bail is part of a normal procedure only. How? Because Article 21 is the basic foundation of this right of anticipatory bail. It comes from the right to life and personal liberty. Furthermore, there cannot be any right formula, there cannot be any straitjacket formula that will fit all the cases, irrespective of the facts of each of the case. And therefore, the Honorable Court said that granting or non granting of anticipatory bail would depend upon facts and circumstances of each case. Then, thirdly, that judicial discretion must prevail. Judicial discretion must prevail means that anticipatory bail will not be rejected on mere technicalities, on mechanical basis. Rather, the court that has been approached with the application has to apply its judicial mind given the facts and circumstances of the case, and then accordingly decide whether the anticipatory bail is whether the case for anticipatory bail is made out or not. And if it is made out, then it should be granted because it is based on the fundamental right of personal right and liberty. Then the court at last categorically propounded that it is not a right that is limited to exceptional circumstances only. Rather, if the court is prima facie satisfied that arrest of the accused person is not necessary in order to investigate the case, then then the relief of anticipatory bail could be granted. Thus, this judgment constitutionalized the right of anticipatory bail. If we may please move to next slide. The next judgment is Sushila Agarwal versus State. It is a 2020 Honorable Supreme Court judgment. And in this case, the Honorable Supreme Court clarified that there is no automatic timeline for grant of for the duration of anticipatory bail, because in the earlier judgments what the courts did that they gave anticipatory bail to the accused. However, it was limited to a particular period of time. For example, that till the filing of the charge sheet you are granted anticipatory bail. That is, as soon as the moment the charge sheet is filed, this protection of anticipatory bail is no longer available to you and the police officers are free to arrest. However, in this very judgment, Honorable Supreme Court clarified that no automatic time limit could be imposed on the cases and protection may continue even till the end of the trial. Therefore, essentially what the Honorable Supreme Court tried to do is to attain a balance between the constitutional right of liberty and the investigation powers of the police officers. Therefore, no arbitrary restrictions could be imposed on the relief of anticipatory bail. Thus, this modern framework of anticipatory bail has been shaped by various landmark judgments of Supreme Court. However, these two are the most important ones. Now, coming to the second part of our session, that is plea of alibi. First of all, we should understand that what does alibi means? Alibi means elsewhere. It literally means elsewhere. So what the accused asserts in this particular plea is that at the time the offense was being committed, I was actually not present at the place of the offense. Rather, I was present elsewhere. So, what the accused says that at the time the offense was committed, I was not present at the place of the offense. Rather, I was present at another place, which makes my presence at the place of the offense so impossible or improbable that it shows that I have been wrongly implicated in the case. So, if the plea of alibi is established, then it raises serious doubts on the case of the prosecution because it collapses the timeline that the prosecution is stating. If you may please move to next slide. So the plea of alibi is based upon Section 9 of Bharatiya Sakshya Adhiniyam, that is erstwhile Section 11 of Indian Evidence Act. If you may please switch to next slide. So what Section 9 of BSA says is that facts which are not otherwise relevant, otherwise relevant means that the facts which are not declared to be relevant under other provisions of Bharatiya Sakshya Adhinam, they will become relevant if they are inconsistent with the fact and issue, or they make the existence or the non-existence of the fact and issue or the relevant facts highly probable or improbable. It will be difficult to explain it in terms of words, so I will like to take the help of an example. Let's say an offense of murder was committed at place X, was committed in Agra at place X, uh, and it was committed at 11 a.m. Right? So, in order to implicate the accused in the offense, that the particular offense was committed by the particular accused, we have to show, the prosecution have to show that that the accused person was present at that particular place at that particular time. That is, he was present at X place at 11 a.m. However, in plea of alibi, what the accused does, he raises the plea that at 11 a.m. I was not present at X place. Rather, I was present at Y place. From let's say 10:30 to 12:30, I was present at Y place. So how can I be possibly present at X place at the same point of time? So this is what essentially the plea of alibi is. If you may please switch to next slide. So what the plea of alibi does is this, that it lays down three important principles. It has three important principles. Number one, that the burden of proving the plea of alibi lies solely on the accused. It is the accused who has to prove that I was not present at the place of offense, rather I was present at present somewhere else. Number two, that the plea of alibi has to be specific in two things: A, in time, and B, in place. That at so and so time, I was present at so and so place. Number three, the physical, that all these circumstances make the physical presence of accused at the place of offense at that particular point of time physically impossible or highly improbable. Physically impossible or highly improbable. However, as regards bail, the accused need not prove it conclusively. Rather, what the accused has to do, the accused has to show prima facie grounds that at so and so place, at so and so time, I was not present, and therefore the case that has been in which I have been implicated is not real. I have been falsely implicated in the case. So the accused only has to raise reasonable doubts in the minds of the court, so as to so as to so as to make the court believe that he should be granted the relief of anticipatory bail. Now coming to the part of drafting. So we have to use, how do we have to use the plea of alibi in the case of anticipatory bail? For example, as I said, in the fact situation that you will be drafting the anticipatory bail application upon, I'll only touch upon the major facts and it will be dealt in detail by another speaker. So, the example is that an FIR for theft was registered that theft was committed at so and so place at 11 a.m. However, in the present case, accused is saying that with the help of dental bill, with the help of CCTV footage and appointment record, that I was not present at that spot at the time when the offense was committed. Rather, I was in a dental clinic getting root canal operation. So my presence at the place of offense is impossible. It is impossible. So on this basis, we will be drafting anticipatory bail application. So what will happen is that if you are able to prove, if you are able to create prima facie ground, then the effect would be that it shows that the FIR that has been registered, it is false. You have been falsely implicated in the crime. Secondly, it shows malified motive of the complainant, that it is not true, the case alleged is not true, and therefore the complainant is acting malifiedly. Number three, that since the case is false, there is no need for my custodial interrogation, which therefore becomes unnecessary. If we may please switch to next slide. So we must see that there is an analytical connection between the plea of alibi and anticipatory bail, because section 482 of BNSS protects is a mechanism to protect right to personal life and liberty of the accused person, and section 9 of Bharatiya Sakshi Adhiniyam declares that any fact which makes any fact and issue highly improbable or probable or altogether impossible, it will also be a relevant fact. And alibi is based upon this particular section, which is used to dismantle the case of the prosecution, and particularly the timeline that the prosecution is stating, thereby strengthening the anticipatory bail application by attacking the necessity of arrest. So, I would like to explain that what the court examines in plea of alibi in cases of anticipatory bail application, what the court will see is that, is the plea of alibi specific, as I earlier stated, in two aspects: number one, time, and number two, place. Secondly, is it supported by documents as in evidence? Are you able to create a prima facie ground of plea of alibi? Thirdly, that is custodial interrogation necessary. Custodial interrogation of the accused person is necessary. If it is necessary, then anticipatory bail won't be granted. However, if it is not necessary, it will unnecessarily lead to curtailment of the fundamental right of the accused person. Then court will be in favor of granting anticipatory bail. And lastly, that the FIR is possibly malicious. If the FIR is possibly malicious, then there is no need to have the accused be committed to the police custody. Now, I would like to explain the drafting structure and core grounds on the basis of a sample. If you may please share the sample anticipatory bail application. Thank you so much. So, if we can look at this sample anticipatory bail application, first of all, there is this, on the top of the page, there is this heading. This first heading is the name of the court that you are approaching to get the relief of anticipatory bail. So it can either be Court of Session or High Court. Herein, it is the Court of Sessions at Patna. If we can look at the second line, it is ABP number dash of 2019. ABP is anticipatory bail number. So you have to leave a dash and the office will fill in this blank. Then, in the matter of applicant versus respondent, applicant will be the person who is approaching the court, that is the accused person, versus state, and if required, also the complainant. So, applicant and respondent. Then, the most important thing is the heading. The heading should show what you are approaching the court, under what section you are approaching the court. So, before the enactment of three criminal laws, CRPC was in existence. So earlier we used to file anticipatory bail application under section 438 of CRPC. However, now there is a mention that it is under section 482 of BNSS. So application under section 482 BNSS 2023 for grant of anticipatory bail. So coming to the main body, the above named applicant, if we can please zoom it a bit more. All right, thank you. Perfect. Yes. So it is the above named applicant most respectfully showeth. This is standard, this remains the same. So the number one paragraph is about facts. You have to introduce the important, the crucial facts. You have to mention FIR number. However, in this case, it is complaint case number because the case has been registered on a complaint. If it has been registered on an FIR, then FIR number, the date of FIR, then you have to mention under what sections the FIR has been registered. It was registered in IPC and Dowry Prohibition Act, so these are mentioned here. However, in your case, it will be BNSS or IPC as the case may be. The paragraph 2 states that it is a technical pleading basically, that the applicant has not approached any other court, neither this honorable court nor the high court, seeking anticipatory bail application. Number 3, paragraph number 3 is that they are showing basically they are giving the background of the case, that how the case was, what is the intent behind this complaint. So they are showing in this particular case that this complaint is registered merely because we were having some family discord, that the complainant had earlier instituted Rupaspur PS case number so and so under section so and so of IPC against the applicant and his family members, which was subsequently resolved through compromise. So, this is giving a background for the present case, that earlier also there was a case that was being registered by the complainant against us. However, it was amicably resolved through compromise. If you may please scroll it. Thank you. In paragraph number 4, it continues that the prosecution case in brief alleges that the complainant was married to the applicant on so and that subsequent to the marriage, the applicant and his family members demanded a car and subjected her to purity. So basically, these are the contents of the FIR that was registered before. If it is further alleged that she was assaulted on this and this date and thereafter treated at PMCH, it is the name of the hospital. It is also alleged that her belongings and minor daughter were taken away forcefully. So these are the factual things that you have to mention in the initial paragraphs of the application. That on the basis of the aforesaid allegation, complaint number so and so was filed and cognizance was taken, and a photocopy of the complaint and order taking cognizance is annexed herewith and marked as annexure 1. So this is important because you have to show that this and this complaint was registered and you have to annex the complaint. This gives credibility to your case because you are giving evidence to the court that there is that this particular FIR, this particular complaint in this case is motivated. It is not true. It is false. We are saying that the present case is not true. Paragraph number 6 is that the applicant is the husband of the complainant and categorically denies all the allegations of physical or mental cruelty, or submits that he has never subjected the complainant to any harassment or demand of dowry. He is denying all the allegations that have been leveled against him by the complainant. That the applicant is innocent, this again is remains standard. You have to say it, that the applicant is innocent and has been falsely implicated in the present case due to ulterior motives. That the allegations made in the complaint are general, omnibus, and devoid of specific particulars. If this is also generally forms a standard part of the application, then if you may please scroll it a bit. That a bare perusal of the medical prescription annexed with the complaint reveals that complainant was treated at PMCH for pain following fall, and to there's no mention of any assault or external injury. The prescription does not record any observation suggestive of physical effort. So what we are saying is that the injury on the basis of which the complaint has been registered, it is not because of what the complainant is saying. It is not been inflicted by the accused person. Rather, it was pain following fall. So we are giving it credibility, giving the credibility to our side of the facts with the help of the opinion of hospital. In the next para, we are also annexing the evidence, the document herewith, that the allegation of dowry demand is false and fabricated. On the contrary, the applicant has been financially supporting the complainant and had transferred money into the account of the complainant's father on various occasions, including on this and this date. A copy of the relevant account statement is annexed herewith. So they are saying that we are not the ones who are demanding dowry. In fact, on the contrary, we are helping the father. We are helping the father of the wife. We are supporting them financially. And in order to substantiate your claim, you are not making baseless allegations, you are not making baseless claims. In order to substantiate your claim, you are annexing the copy of the accounts herewith. So this substantiates it. Paragraph number 11, that the complainant left the matrimonial home on her own volition without any justifiable cause. So we are saying that we are not the ones who did anything wrong. Complainant is the one who herself went away. If you may please scroll it a bit upwards. That even at the time of leaving the matrimonial home, and so pleading. So these are basically why we are giving reasons as to why the present complaint has been filed. We are basically saying that we are not the ones at fault. Rather, the complainant was the one who herself went away. We did not force her in any way. That the present complaint is a result of matrimonial discord and has been exaggerated into allegations of dowry demand and cruelty, which are false and unfounded. So herein we are giving the court, giving the honorable court a measure, a ground that this particular complaint is not true. It is false and fabricated. We are just being implicated in a false case. That the applicant is a law abiding citizen with no criminal antecedents. You have to declare this, that if you have criminal antecedents, and if you don't have any criminal antecedent, if you don't have any criminal antecedent, then you have to declare it. It shows, it serves your purpose. It is in favor of the accused person, the applicant. That the applicant undertakes to cooperate with the investigation and to abide by any condition imposed by this honorable court. So herein we are giving additional grounds to the honorable court, that if the honorable court grants us anticipatory bail, the relief of anticipatory bail, then the conditions that this honorable court will impose, we are ready to abide by those conditions and we'll fully cooperate in the investigation. So this also has to be included in every anticipatory bail application. This is also a technical pleading. If you may please scroll it. Thank you. That the applicant shall neither abscond nor tamper with evidence or influence any witness. That custodial interrogation of the applicant is not required in the facts and circumstances of the three cases. So, essentially, what we are doing in the last three paragraphs is we are satisfying, we are trying to plead that we are satisfying the triple test as mentioned earlier. Then the last paragraph of the application is prayer. This is the most crucial, the last but the most crucial part of the application, because here we categorically claim what we are coming for what we are coming before the honorable court. In view of the facts and circumstances stated here and above, it is most respectfully prayed that this honorable court may graciously be pleased. This remains as it is, only wordings may change. Number one, direct that in the event of arrest or surrender in connection with complaint case number so and so, you have to be specific that in FIR number so and so or in complaint number so and so, as the case may be, the applicant be released on anticipatory bail to the satisfaction of the learned SDJM Patna. This is the name of the Yes, the applicant be released on anticipatory bail to the satisfaction of the learned SDJM Patna. So that anticipatory bail, if the relief of anticipatory bail is granted, then we will furnish proper security and whatever is demanded for furnishing bail. Second, that pass such other order or orders as the honorable court may deem fit and proper in the interest of justice. So the second prayer uh, is written in almost every kind of pleading, and this is a standard, so we have to include it. The number one is the most important herein, and we have to mention the complaint case or the FIR case in what we are in which we are demanding in which we are claiming the relief of anticipatory bail. And then comes, and for this is the standard pleading, then place and date at which the application was made, then applicant, and then the counsel. If you may please scroll it a bit upwards. Yes. So this is another part of the application. We have to annex an index along with this application. So the header remains the same. You have to write the name of the court, the application number in the matter of applicant versus respondents. Then application under section, the name of the application. Please scroll. So we have to make an index wherein serial number, contents, and page number. So contents are number one, the application, the anticipatory bail application. Number two, the annexures that you are annexing along with the application. This is important because if you do not, we have to, number one, we have to mention the annexures in the expressly in the application itself, and then we have to file a copy along with the application, and we have to mention it in the index. So both the annexures have been mentioned, then vakalatnama of your advocate. So with this, I would like to conclude that criminal law must investigate crime, but it must not crush liberty in the process if not required. Anticipatory bail ensures that investigation proceeds, but without converting the acquisition, without converting the acquisition into punishment. It is not about escaping the law. It is not about escaping the law. Rather, it is about preventing misusing of the law, preventing the abuse of the law. A well drafted bail application does not beg. We have to pay attention that a well drafted bail application does not beg, it demonstrates. We have to demonstrate with our pleading, with our words, carefully drafted words, phrases, along with the documents, along with the annexures, that we are here and we make a case for granting of anticipatory bail in our favor. So this is it from my side.
Good evening, ma'am. So from here, I will take the question session. So if you are comfortable, can we proceed?
Yes, please.
Right. Okay, ma'am. So the first question is from Raghavendra Kumar. Ma'am,
Yes.
under BNSS 2023, has the judicial approach to anticipatory bail become stricter or more structured? What trends are you observing in trial courts?
So there is no, actually, there is a difference between the provision of anticipatory bail in the erstwhile criminal law, that is CPC, and the present BNSS. However, there is no material change. What we have, what the legislature has deleted, if we may please look at CRPC, they have omitted they have omitted the later part of main section 438 clause 1 that laid down the grounds on which anticipatory bail has to be weighed. And secondly, they have deleted the provisions regarding interim bail from this particular section. However, these are the provisions that are otherwise also followed in practice. There is no material change as such from CRPG to BNSS. There is no substantive change. The procedure, the the procedure remains the same, the grounds remains the same, conditions are also imposed, that also remains the same. So there is no substantive change. There is no change in the practical reality as well, from what I have observed.
And ma'am, the second questions deal with from the gestury point of view. If FIR is lodged, whether we want to file application or a quashing of FIR petition.
Yes, that is also something. So we have to file quashing if we want that. We think that we know that the FIR is false, we are falsely implicated, then we should surely go for quashing of the FIR. However, for the meantime, just to be on the safer side, we also go for anticipatory bail, because anticipatory bail is for your prevention from being humiliated, because arrest is something that is treated in our society. With just arrest you are treated as a criminal, right? We know the reality of a society. So anticipatory bail is a kind of protection, it is a kind of prevention that we take, so that in the event of arrest we will be released from the from the custody of the police officer itself. We do not need to go to the courts, because if we go to the courts, if we do not get anticipatory bail, then we'll have to drag it, because bail matters take time. Even if we say that we have filed the bail application, but it takes times. So it is preferred that we go for anticipatory bail application. Alongside, we can also file for quashing under inherent powers of the High Court, definitely. But it is also advised to go for anticipatory bail application side by side.
Ma'am, third question deal with the same thing only, the time limit of the after the FIR lodge. What are the time limits?
There is no particular time limit as such that is specified in any statutory provision. It depends. First of all, what has to be seen in the cases of anticipatory bail, that there has to be an apprehension of arrest. The accused is has a reasonable ground to have apprehension of arrest. Mere fear is not enough. So, if no FIR is lodged against you, let's say there is a fight between two groups, and one group has lodged FIR. So, if FIR has been lodged, the police are investigating, and you apprehend that police may arrest me. You apprehend on the basis maybe like other accused persons in the FIR, the persons who have been implicated, they have also been arrested. So you are apprehending that I may also be arrested. So on that basis, you go for filing of anticipatory bail. So it is advised that as soon as FIR is there, you go for filing of anticipatory bail, so that uh, it does not become infructuous. Because if once you are arrested during the investigation by the police officers, then the application of anticipatory bail becomes infructuous. If you are arrested, you have to go for regular bail. You cannot go for anticipatory bail. So as soon as FIR registered, as soon as you get apprehension of arrest, go for anticipatory bail application.
Sure, ma'am, it do justice to the answer. Ma'am, so the third question is from Shipra. Ma'am, as you have said, police can arrest the person even after getting the anticipatory bail, then why we need it?
Actually, there is a practicality behind it. In case FIR is registered, a person is arrested. In a normal case, person is arrested by the police in a non-bailable case. Okay. Now, what we have to do is we have to go for filing a regular bail application. But what is there? The accused has already been arrested. He is either in police custody or languishing in jail. So his fundamental right to life in personal liberty is already curtailed. Maybe it was necessary, maybe it was not necessary, but he is already languishing in jail. So, in order to ensure that I do not have to go to the jail, I do not have to languish in police custody, what is done that we approach the court, get an anticipatory bail becomes operational when police arrests you. So, once police arrests you, now you have to show them that this is the anticipatory bail. Honorable Court of Session or High Court have granted me anticipatory bail, and now you have to. The police officer does not have a discretion. He cannot refuse. He have to release that person of bail. So what essentially this anticipatory bail does in cases of bailable offenses, as seen in the cases of bailable offenses, you get bail from the police station itself. So what we are doing by way of anticipatory bail application is that we are converting non-bailable offenses into bailable offenses so that we do not have to go to the court after the arrest. We get the bail from the police itself. That's why we go for anticipatory bail.
Ma'am, so the other question is from Rohit. How can we say that it is effective in adjudicating the justice in a case of offense highly grievous in nature?
So, anticipatory bail is not an indefeasible right. It is the discretion of the court. If the court is satisfied that no prima facie ground is made out, or that you have been falsely implicated, that most importantly, that custodial interrogation is not required, then anticipatory bail will be granted. If the court is of the opinion that you have committed the offense prima facie, you have committed the offense, or that the offense is grievous, they are allegations of serious nature, then you won't be granted anticipatory bail, because bail is the discretion of the court. Bail is discretion of the court, and it depends upon the facts and circumstances of each case. And if we also look at the provision in section 482 clause 4, it says that in case of sexual offenses, anticipatory bail won't be granted. So sexual offenses are one of the examples of grievous offenses, and therein there is no provision for anticipatory bail. So in grievous cases, this is for the court to decide whether the case is grievous, whether the accused has been falsely implicated. So it depends upon facts and circumstances of each case and the judicial discretion.
Ma'am, that is absolute true because cognizable offense or non-cognizable offense make a lot of difference. So the other question is in relation to Jayashree. If anticipatory bail is rejected or quashed, can we file appeal?
Sorry, if you could please repeat the question.
So Jayashree asked if anticipatory bail is rejected, can we file a appeal?
Anticipatory bail, yes. In case you have filed an anticipatory bail in the Court of Sessions, then you have the option to go to Honorable High Court. And that is why, in practice, it is always preferred to go to Honorable Court of Sessions first. And even if not written in the statute, but also the High Courts are inclined toward this notion that the hierarchy of courts should be respected, and therefore we should approach the Court of Session first and then the High Court. And even if we have approached the High Court first, then also we can go for appeal. Yeah.
Yeah, ma'am, the court hierarchy matter lots. So, ma'am, the other question deal with Raghavendra Kumar. So, ma'am, when should we avoid filing anticipatory bail and instead wait for regular bail?
I believe why would a person not file an anticipatory bail? Because It comes in two scenario. Let's say if the person thinks that he'll be arrested next day, so it is not practically possible. It depends upon facts and circumstances of the case, but ideally advocates advise that you should go for anticipatory bail if you are apprehending arrest and you have grounds, right? But if the facts are such that police may arrest you tomorrow only, then what is the purpose of filing anticipatory bail? You will take at least 1 to 2 days to get it prepared. You will take around, if not days but hours. You will file it, then court will fix date for hearing. So it is, if not a lot of time, but it takes time. So if you have time, you think you have time, then you go for anticipatory bail. Why would someone want to go to jail first and then file regular bail? So anticipatory bail
Yeah,
is always
ma'am.
preferred.
So this is the last question and very interesting. Is there any reform needed in the concept of anticipatory bail or a plea of alibi tackling with the current and future cases?
What I believe that the statutory framework that we have been provided with, it is ideal because it takes care of every possible practical situation. It takes care of the grounds on which the anticipatory bail should be granted, what all considerations have to be kept in mind while granting anticipatory bail, and what conditions that have to be imposed if the court finds the case fit for granting of anticipatory bail. Then it also mentions the offenses wherein the provision of anticipatory bail is not at all available, the as I mentioned in the cases of sexual offenses. So the statutory framework is perfect. What we have to look at that how judiciary is approaching it. So the concept of anticipatory bail is um, it has developed over a period of time. As I also mentioned the landmark judgments, I said that earlier what the court used to say that it is available only in exceptional circumstances, right? But now it has been clarified by the constitutional bench of honorable supreme court that there is no need for exceptional circumstances, because the concept of anticipatory bail is based on the very foundation of article 21 of the Indian constitution, that is the right to personal life and right to life and personal liberty. It is a fundamental right, the basic human right, and therefore this relief of anticipatory bail cannot be made limited to exceptional circumstances only. If the grounds are made, if the judicial if the court thinks that the accused won't flee the court, he will satisfy the triple test, then obviously the relief of anticipatory bail should be granted. You cannot curtail the fundamental rights on slight grounds, right? And then also, I also mentioned about how the relief of anticipatory bail cannot be made limited as per the time. It should be not that, it shouldn't be like that we have granted you anticipatory bail, but only for the time being, only till the charge sheet is filed. So we should not make it conditional unnecessarily. Obviously, if there are conditions, obviously, if there are facts and situations that demand in the judicial mind that accused should be given anticipatory bail but for the limited time period, then it can be done. And as regards plea of alibi, that depends upon the facts and circumstances of each case. If the accused is able to show that he was not there at the time when the offense was committed, then it will obviously weigh heavily, in fact, heavily, while deciding on the plea of anticipatory bail. And these are factual situations. You have to present evidences, and it is better to present documentary evidences. You have to lay background to your case that this FIR is not true, it is motivated, it is malicious, you have been falsely implicated to make out your case. So, yes, these are all factual things, and you cannot be saying that. Obviously, the statute is proper, but judicial reasoning, judicial trends keep on changing as per the requirements of time.
Thank you, ma'am. It was truly honored to get your experienced answer, and we truly value your time. Thank you.
It was my pleasure.
Thank you so much, Priyansi ma'am. That was a master class in defense strategy, and the way you explained the difference between regular bail and anticipatory bail under the section 482 of BNS was crystal clear. And we now understand that a bail application isn't just about saying my client is innocent, and it is about proving that the arrest itself is malicious and unnecessary. Thank you for showing us how to build that argument. Thank you very much for you, ma'am. Here.
It was all my pleasure.
Ma'am, if you have limited time, then we value your time. You can leave it. We don't have any problem. And interns, you are requested to be here because there's some important message to share with you. All right. Before sharing the important message, that message will be shared by your internship coordinator, Tisha. But before that, let me explain about your task 3. Your task is now live. Interns briefing is done, and your client is Rahul, the same guy, a college student, a vindictive neighbor, has filed a false FIR accusing him of theft. The police are looking for him. Now, twist here is Rahul has an alibi. At the exact time the neighbor claims that theft happened, Rahul was sitting in a dental clinic getting treatment. He has the bill and the CCTV footage. Now, your job is to stop the arrest. You must draft an anticipated bail application that to be filed in the session code under section 482 of BNSS. And do not write a generic plea. You must explicitly plead that the plea of alibi, you must attach the rental bill as an annexure. If you don't use those evidence, the judge will assume he's guilty. And the format and the criteria is same. The coming Saturday is your deadline. That's 21st of February, 11:59 p.m. Thank you very much. And Tisha is going to share you some small important message.
Okay, so folks, before we formally conclude this session, I would like to invite you all to our next biggest event, NVIMUN, Nyayavani Model United Nations Conference, where students, professionals, and change makers will be joining from across India and from abroad as well. It is scheduled in Dehradun on 25th and 26th of April 2026 this year. We have all the facilities of accommodation. It will be a 2-day conference followed by ice-breaking socials and DJ nights and award show. To get more information on this, you may text your team leads or directly to me. We would be glad to welcome you all in Dehradun. We are excited to meet you all in person. So here is a formal invitation to you all.
All right, interns. So invitation has been transferred to all of you, and also the task tree has been sophisticated to all of you. Now your work starts from today, and do also think about the invitation that has been given by Tisha, the internship coordinator.